Hello, everyone. I'm Jeff Hampton with the Fulgham Law Firm. Thanks for joining us here today. How do you get a theft case dismissed? By the way, if you wait around till the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Now, today, I want to cover with you the ins and outs of theft law, basically give you a general landscape of what the laws say in Texas regarding the crime of theft, and help lay out for you a few defenses and a few things to help kind of get your feet under you to prepare for either yourself or your loved one if you may be facing a theft charge in the North Texas area. Now, one of the things that we look at from the very beginning is, why does it even matter? Is theft really all that serious of a crime? Well, we're going to identify that theft can range anywhere from a ticket, a Class C misdemeanor, all the way up to a first-degree felony. But I will tell you this, theft is a little bit of a unique type of case because even a misdemeanor theft charge can have tremendous ramifications on your future. Many employers look at the crime of theft and they see it as a crime that is a crime of dishonesty. So their concern is that if they see someone, even with a minor theft charge, even if it's a shoplifting case, if they see someone being charged with that, they begin to think they can't trust that person, and now it can become sometimes nearly as difficult to find a job with a theft conviction on your record as it is a felony on your record. So it's very important that you work with an attorney that knows what they're doing and that helps put together a plan of action to help try to make sure and keep this off of your record. Now let's first identify the types of theft. Now under Texas Penal Code section 31.03, this governs theft, and theft is generally defined as the unlawful taking of another's property. Now, what does that mean? Well, when you take someone else's property, the real question is, you say, how is it unlawful? Was the property taken with the intent to permanently deprive the owner? And so that's the real inquiry here. So some of the examples of different types of theft in Texas is, of course, the most common is shoplifting, okay? That's number one. You can also have, some people talk about grand theft auto. There is no such thing as grand theft auto as a charge in Texas, but there is, that would be under a felony theft designation. And we're going to get into that in a second because theft is based upon the value. The more expensive the item was that was taken, or whatever it was that was taken, the more expensive, the more serious the ramifications are, and the higher the level the charge is. So you could be talking about whether it's auto theft, whether it's theft of a firearm, whether it's shoplifting, whether it's just standard theft. You have variations of theft, credit card, debit card abuse, different things like that, fraudulent use, possession of identifying information. Those all kind of tie in together with the general purpose of a theft charge, okay, is to try to protect people's property, and someone should not have to worry about their property being permanently deprived from them. Now let's talk about the penalties for theft, because here's where it really breaks down, okay? If the item being taken was less than $100 in value, so theft under $100 is a Class C misdemeanor. What that means is a Class C misdemeanor is punishable up to a $500 fine, no jail time, but $500 fine only. But remember, if you just walk into a courtroom and you just pay that fine, you have now pleaded guilty to that theft charge, and you now have a theft on your record, and that can have dire consequences, okay? So even though it might seem like a minor charge, it's still very serious. Don't just go in and pay the citation, all right? Now, what if the value is between $100 and $750? Now you're talking about a Class B misdemeanor that is punishable by up to 180 days in jail and up to a $2,000 fine. If the value of the item is $750 to $2,500, now you are talking about a Class A misdemeanor. And that's a Class A misdemeanor is punishable by up to a year in county jail and up to a $4,000 fine. What if the value of the item is over $2,500 but less than $30,000? Now you're talking about a state jail felony. This is where a lot of auto theft comes into play, okay, in this range, used vehicles especially. Now you're talking about a state jail felony that is punishable by up to 2 years in prison and up to a $10,000 fine. If the value is $30,000 to $150,000, now you're talking about a third-degree felony, up to 10 years in prison, up to a $10,000 fine. If it's 150 to 300,000, it's a second-degree felony, right? That's up to 20 years in prison, up to a $10,000 fine. And if you get over $300,000, you're talking about a first-degree felony. Technically, that's up to life in prison, okay? 5 to 99 years or life in prison for that amount. Now, what are some defenses? This is what some of you may be kind of waiting for. Tell me what some things I can do as a possible defense to the crime of theft. Well, here's some of the most common defenses. Number one, that it was an accident or a mistake. Okay, this happens a lot in the realm of shoplifting. I always think about someone that many times there's different stores that you go to, and they think that you're trying to skip scan something, or they think you go through a self-checkout line, and we've seen people that left the dog food on the bottom of their cart, but they paid for everything else. Well, in that situation, remember, the state of Texas must prove each and every element of theft beyond a reasonable doubt. If there's evidence that someone paid for all the other items, but they failed to pay for one specific item, there may be some good circumstantial evidence to establish that there may have been no criminal intent. This must be proven that you did so intentionally or knowingly. You had to have meant to do what you did, okay? And if they can't prove that, that's a problem for the state of Texas. So if it was an accident or if it was a mistake. The other option is, number two, what if there is no proof of intent to permanently deprive the owner of the property? What if the item was being borrowed and then it was being returned? We had someone who was using someone's property and they had been given consent to use it in the past, and they had texted the person back telling them they were bringing it back to them. Thank you for letting me borrow it. That person got angry before they told the police about it, went and had that person get a warrant for their arrest. We were able to show there was no intent to permanently deprive them of the item. Okay. Now, what if, here's a good defense, what if the item was already paid for? And this doesn't happen as frequently, but we've had some people come back, and boy, I tell you what, learn a lesson on this one. Don't ever buy something and decide you're going to go back to the store to return it and not return it first. Because if you go back into that store and you start looking around in the store, and then you go back up to the customer service to try to return it, many times you're going to run into problems. They're not going to believe you. And that's what we've had clients where that's happened. They went and they tried to look around the store, and on their way towards the front, they end up being apprehended. They had to show proof that they had already actually paid for the item. Okay. There can be other examples, mistaken identity. Okay. You can have the wrong person. We've had this happen many times where they didn't actually apprehend the person at the store or at the location, but they have some grainy video footage that you can't even really tell who the person is until you're able to determine some type of identity mark, like a tattoo or something like that, that does not match up with the person who was supposedly committing the theft. In that situation, if you have an issue with mistaken identity, you have a good defense. Okay, finally, what about abandonment? And this one seems kind of rare. But I mean, listen, there are neighborhoods where you leave something out on your curb for more than about 5 minutes, somebody's going to be out there to pick it up, and I mean, take it away. Like in that area, it's known as, if you put it on the curb near where the trash comes up, you're abandoning your property. Well, we've seen instances where someone came and thought that they had a right to pick it up because they thought it was being thrown out for the trash, and then the property owner calls and says, hey, this guy's stealing my stuff. Our client was under the impression that it was left to be abandoned and thrown in the trash. So there's examples of this. If someone abandons their property, or if there's a good faith belief that it was abandoned and that the original owner did not want it anymore, that is a good defense for you. All right. Now, those are just a few of the defenses. Maybe you are facing a theft charge in the North Texas area. If you would like a free consultation, don't hesitate to contact the Fulgham Law Firm at 817-877-3030. By the way, I promised you if you waited around to the end of this video, I would also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Click the link below, input your information, and we'll be happy to send it right over to you. By the way, if you liked what you've heard here today, like our video, subscribe to our channel. We'll send you more great content just like this. Thanks again for joining us here today. Look forward to seeing you on our next video series.